Good morning, everyone. Welcome to Assembly Judiciary here in Carson City, as well as to those that are down in Las Vegas and anyone watching on our legislative YouTube channel or through Nellis. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orenlicker, Roth, Urick, Chair Miller.
Here, thank you. And just a few reminders before we begin. Please make sure you turn off the volume on any of your electronic devices. Also know that members may appear to be coming and going as they may have to present in other committees during this time, but also that please don't take folks looking at their electronics as a sign of distraction or disrespect. Everyone is researching and communicating as well. With that, today we do have 3 bills that we will hear. I will take the bills in order. I will provide the phone number and the meeting ID right now for anyone wishing to testify or make public comment through the phone. The phone number is 888-475-4499. And the meeting ID today is 899-030-10205. We, of course, ask anyone presenting a bill to please keep their remarks to 15 minutes, and anyone testifying on a bill or making public comment today to keep their comments to 2 minutes. With that, we will remind you to make sure that you state your name and spell it for the record the first time that you speak. And with that, I will go ahead and open the hearing for Senate Bill 121, which revises provisions governing common interest communities. Senator, your hearing is open, so whenever you are settled and ready to begin, please proceed.
Thank you. So good morning, Assembly Committee on Judiciary. I am Senator Dina Neal, here to present SB 121. So SB 121 is basically an HOA bill. I'm making a baby step into trying to figure out how homeowners can have more of a say in certain areas involving their home in which they are paying a mortgage. And so I'm not going to, do this whole presentation. I'm just going to jump right into the sections, and then you guys can ask me questions. So in Section 1, the reasoning behind placing this information in here where I'm going to deal with the actual landscaping in the backyard. So when you typically buy a home, right, initially buy a home, you have 180 days in which you have to landscape the backyard. When you move in, most people have spent most of their money on, the refrigerator, the blinds, the furniture, and they actually don't have the funds. And so I wanted to try to give wiggle room to homeowners who are moving into their first home, trying to figure out how they're going to pay for it, and then give them some flexibility. So basically this provision allows that they have to do a layer of rock within 18 months after they close from escrow, and then in 36 months, then they have to do the full landscaping in their backyard. The reason why I put this in here is because if you've ever tried to landscape your backyard, and I guess the wonderful design that you may be considering, it's at a minimum sometimes $17,000 to $27,000 for you to actually put into your backyard. And so I was trying to allow homeowners, number 1, time, 2, control, 3, just the ability to make a decision on how they can plan to move forward. So in Section 2, this particular provision came up around the late fees not being more than 30 days, because if any of you stay in an HOA, the late fees sometimes are 10 days, 15 days, but it is not in an alignment with just, that the late fee is going to pop up on your HOA in 30 days. And so the provision in here also says that it cannot be reported to a credit collection agency. And so it was super important for me just to have some kind of alignment around when do you expect to get a late fee when you have not, when you're late? So, because there were issues in my particular district where they were saying, how is it that I can get a late fee on 10 days and then this other HOA I can get a late fee 15 days later? Why isn't it just a standard Fair Debt Collection Act 30 days? And so that's what that provision is going after. In section, on page 5, section 3, this is related to the oil stain. So also, this popped up in the district where folks are parked out in front of their house. This is not a driveway, where you have an oil stain on the asphalt, right? So the black asphalt, and then you're being told you need to go and scrub the asphalt and get the oil stain off the asphalt. And so I know when I saw the reprint, I was like, is that really saying what I wanted to say? But it is, because basically it's saying that a tenant or invitee who comes to your home would be responsible if they committed the oil stain entirely in the driveway. And so the way that it was written is kind of, to me, it was written in the reverse. When I first read it, I was just like, this is wrong. I want you to say it's the asphalt. And they were like, no, but if it's entirely in the driveway, clearly you're responsible, right? Go get your kitty litter and clean it up. So the next provision in the bill is dealing with, this is on page 6, which is dealing with the commercial advertisement, and it also has the size and weight of a vehicle, and it has some exceptions. So what prompted this particular section of this bill was basically, I've always supported like small business owners, and most small business owners park their car in their driveway. Or there are employees who actually get the blessing of having a work vehicle that they can take home. Well, there's certain HOAs that have CC&Rs that basically say that if you have any kind of advertisement on the car, you need to cover it with a magnet. And if you don't cover it with a magnet, then you're at risk of getting fined and potentially towed. So this actually happened in my neighborhood where their work vehicle was towed because they were parked on the street. Now, they didn't know, or remember, right? Because if you moved into your house 14 years ago, how many of you are going back and saying, what did my CC&R say when I first moved in? You probably don't remember. And so what they found out was that their CC&Rs basically said no advertisement, and that they were required to put magnet on the car in order to prevent from being towed. So the car was towed. They went to the HOA ombudsman and found out that the CC&Rs basically said, you have to cover the vehicle. And you're also responsible for paying for this tow fee and to go get it out. And so they had to find magnets that matched the color of the car. And every night while they were working for their employer, cover it up. And, running through this anxiety like, oh my God, it's midnight and I forgot to put the magnet on. And so I wanted to, couple things, right? I thought that was crazy. 2, I really felt like I think this is a little bit too intrusive. And because I started thinking, well, what if you're a small business? What if this is your car and you're parking in front of your house that you're paying a mortgage on, and then all of a sudden you feel like you can't park in front of your house? And so I wanted to create an exception in the law, so that, number one, you're not being mandated to put this magnet on your car. Now, there are exceptions in this section, right? Or when I talked to the management companies down south about, we got into a conversation around, okay, well, what if it's pornographic images? What if it's marijuana? And I was like, okay, all right, these are the 2 exceptions that are actually in the bill. And I was like, but we can't keep, following down this line of, all of these other things that you would like to put in here, or else it's going to eliminate what I'm really going after, which is I actually don't want anybody forced who has a small business or who's working, has got a car from their employer, being forced to have to cover up the side of their vehicle. The next section of the bill, which is on page 9. So this came about because basically you could have a management company that terminates, meaning you now have a new management company and you would like to have notice. So what has happened, or the issue that popped up, was that an HOA management company transferred and they didn't know. And so when they went on to pay the dues, ultimately, they were like, this management company is no longer over your community. And so they were like, well, who is over my community? And didn't know. And so I was just trying to make sure that there's like a timeline for when, if you know you're going to terminate, that you actually let those community members know that you're actually going to terminate. The backside, which is the provision that's on the last page of the bill, came up in my conversation with the community managers, like, because they were saying that it's a common problem that when they terminate, they're also not transferring the accounts, records, and books, so that you know, like, what are the dues and what are the different things that weren't paid, so you can have an idea. And so that provision said within 30 days of the termination, you must then turn over the books, records, and everything associated with that community. And so those were some of the common sense provisions that I was looking at. Some of the complaints that popped up in the provision on page 9 on the posting. You know, in my mind, I was like, most of us that live in an HOA have a community mailbox. Posted on the mailbox that you've terminated and you've moved on. So you've gone from company, Acres to company Misty. Put it on the mailbox so I know who to pay. And so really simple, but everything that's simple in this building, as you have learned, people will overthink it to death and say, I don't know what a common area is, and maybe this common area, maybe I have a sliver of a common area, so I don't know how I'm supposed to post this notice. And you're like, well, Jesus Christ, come find me. I'm saying find the common area, post it up, and let somebody know you've transferred the HOA, so not paying the wrong person. However, it was still, and it still is, a conversation about the common areas. But basically, that's what the bill does. And Madam Chair, I will open myself up for questions, and I may or may not have jokes somewhere in between.
Thank you, Senator. You already got one joke in, so we'll try to enable you to get a few more in this morning. I do have a question before we go to members' questions. I know that you presented off of the reprint of your bill. I know there was an amendment submitted, and I'm just wondering if you're accepting it.
Madam Chair, I haven't decided if it is friendly or not. There are provisions I appreciate, and there are provisions I do not.
As a dais full of bill sponsors, I think we appreciate and understand that. So then at this point, we will not consider or ask questions regarding that amendment. And I look forward for your final answer as a bill sponsor on which direction you'll be moving. With that, our first question comes from Assemblymember Cole.
Good morning. I hope my question gives you an opportunity for another joke on a Friday. I appreciate that. So my question is related to the collection process with HOAs, and it's actually recently come to my attention that there are property management companies or HOA management companies that also have created their own collection agencies, and they're doing agreements between each other and not disclosing necessarily. So I'm wondering if there's a way for you to maybe add something into the bill that says that, a property manager, if you're going to accept a bid and enter into a contract with a similarly owned company for collection purposes, that you have to disclose it at least, or maybe even prohibit it. Would you be willing to do that? Thank you.
Thank you for the question, Madam Chair. To you, okay. To Assemblymember Cole, that actually was something that was brought up to me the other day. It's something that I'm thinking about because I actually didn't know that existed, that they had created their own debt collection agency, and I was wondering if the language that was in the bill would prevent them. And so I'm actually interested in that because I do see it as a conflict of interest, but I just wanted to make sure that number one, I researched that a little bit more so I could get more documentation, because it's not like, if it's not something they're disclosing, it's not like we're all of a sudden going to be in this committee hearing and we're going to get HOAs confessing. Maybe we will. But that would be nice. And then I would be like, bingo, gotcha. It's in the bill. All right. So, but I'll definitely consider it. It was Assemblymember Gallant who actually brought that to my attention. Thank you.
Thank you. And we do have that little sign down there in case you need us to. All right. Our next question is from Assemblymember Gray.
Thank you, and good morning, Senator Neal. Good to see you back here in rare form. Question: I am in no way a big fan of homeowners associations, but people typically move there for a reason, and I'm wondering. I mean, they get absolutely crazy sometimes enforcing their rules, but a lot of those homes are bought by people with small businesses, and I just the provision in there about signage on vehicles and stuff, that one just kind of gets me a little bit. I mean, because most of the neighbors, I don't know, but anyways, do you think that one might be just going a little too far since those are in and out and they're not full-time display? I mean, I think we're trying to fix a problem that's really not there.
Senator Neal, for the record, meaning, okay, so you don't want them to have to, you want them to cover their cars with a magnet?
Clarification, maybe I read it wrong, but no, I don't want them to have to cover their cars with a magnet. I mean, the other parts, cleaning the driveways, the asphalt, absolutely. But, I mean, there should be no, I don't know, I don't think there's not that many, I don't think, that I've seen in the communities I've been in, but, and maybe I read the bill wrong, but.
So the provision on page 6, sub C, lines 36 through 44, and it kind of continues on the back page, was making sure that they don't have to cover the car with a magnet.
Thank you, my mistake. I've got to work on my reading comprehension at 3 o'clock in the morning.
Okay, our next question is from Vice Chair Marzola.
Thank you, Chair. Hello, Senator. I appreciate the jokes in the morning. So my question is on Section 1, subsection 2. So you stated earlier that, so I buy a home, within 18 months I need to lay rocks. And then within 3 years, I need to do my backyard. So if I choose that I don't want any rocks in my backyard, right? And I want plants and grass or what have you. So now I'm having to pay to take out those rocks and redo my backyard again. So why not just give the new homeowner 3 years to do their backyard, period?
Senator Neal, for the record, Assemblywoman Marzola, that's how I started off, right? But over the summer, when I was meeting with the management companies, there's a very strong interest in backyards, apparently. They want some form, and they talked about, how when you have that, the dust in the Vegas Valley and the dust moving and not having some kind of rock or some kind of layer over there to prevent, basically dirt from flying up in the air, and then just having some level of landscaping, they felt very strongly about that, and that was my negotiation. Now, I mean, as all things in this building, right, it's up to this committee to decide if there's some change that they want that will allow them to move this out of this committee. But if you look at, because I agree with you, I just want a window, I want wiggle room. But that's some of the things that they came up with. I personally have had a huge problem with whoever the neighbor is that has decided that they want to peek over your back wall because they don't have anything better to do. And I feel like that's gone too far. But it's up to this committee. It's probably going to put this back into conflict because I did work with folks in the summer to come to that particular section, but it's the pleasure of this committee at this point. I mean, because you have an amendment that I also has a different time period, right? 12 and 24 months.
Thank you. And I don't want to blow up your bill, right? I know you've worked hard, but I think if the thought process is, I'm buying a home, I'm putting all of my life savings and purchasing that home, and now I'm having to pay double the money to get my backyard fixed. I don't see how that's advantageous for the homeowner. but I will defer to you, Senator. I just wanted to clarify, I just wanted to see what the thought process was in that section. Thank you. Thank you, Chair.
And Chair, can I just add something in? So, Senator Neal, for the record, so on the other side on the Senate hearing, you'd be amazed at the belief systems around houses. Because what popped up in the Senate hearing was, if you don't believe in an HOA and don't want to landscape your backyard, then you should get up, you should move, and you should find another home that's not an HOA. And there was also things said on the record about folks being lazy, and they're like, well, clearly, they're too lazy to actually go out and landscape their backyard, not actually considering that, you're just financially strapped after just moving in, right? And not everybody is sitting on, a bag of gold and can just turn around and just, landscape their backyard because they're focused on the inside. And so there were just very interesting comments on the Senate side that I felt were just very classism and just like, okay. And so I don't know what you're going to get in opposition over here, but that's what happened on the Senate side for this particular section. They objected to it generally.
Thank you, Chair. I appreciate that, Senator. I can tell you I'm not lazy, but I'm a single mom who, when I bought my first home, I didn't have $1 left in the bank and definitely could not have done my backyard in a year, 2 years. And so it's sad to hear that happened in a Senate hearing or that happens in this building. Thank you. Thank you, Chair.
You're welcome. And yeah, I think that's the hardest part for me is when I hear all the isms that happen in this building from people that are supposed to be protecting the people of Nevada, or the hypocrisy. With that, we have a question from Assemblymember Nadeem.
Thank you so much, Madam Chair. Thank you so much, Senator, for the presentation. I want to ask a question related to what the Vice Chair just said. It's about the backyard. So it is, thank you for bringing it up because right now it is so expensive to do the landscaping for the backyard, especially for a new house. So Senator, I want to ask you that what is the time frame as of now? If these changes, they don't occur, or when they will happen, but what is the time frame for now?
Senator Neal, for the record, most of the CCNRs have 180 days, so 6 months.
Can I have a follow-up? Sure. Thank you so much. Thank you, Chair. So, okay, that is 6 months. That makes sense because it is, then after, if they are not able to establish it in 6 months, then they have to pay fees after fees, penalties after penalties.
Well, you will get a notice saying that your backyard has not been landscaped, and you will, they typically will offer for you to do something, but you have to turn in a plan what you're going to do. And if it's the one layer of rock, then you need to establish this one layer of rock, and then you need to take a picture of that and then turn it in. But sometimes even just go get the dump trunk, go to Home Depot or Lowe's, and then go get that layer of rock and then get it dumped into the backyard. Sometimes you can't even afford that within the 6 months. I mean, we're assuming that everyone is financially equal when they move into a home. Home ownership is very important. Achieving the American dream is very important. But not all people are walking into a home with the same amount of money in their bank account, right? And so sometimes even that simple task is actually very expensive.
Thank you so much, Senator. That is so helpful. Thank you.
Thank you. We have another question from Assemblymember Cole.
Thank you, Chair, for the indulgence. So my question is really more for legal department, I think. So understanding that CCNRs are covenants that run with the land and they're restrictive covenants in most parts, how does that interplay with NRS when we make a change like this? Does that affect just CCNRs going forward for new CCNRs, or does it impact those that are in existence right now and supersedes those? Thank you.
Carly O'Krent for the record. I would think from a contracts perspective, it would be moving forward.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. It's good to see you. Thank you for being here. God bless you. HOA bills are difficult. As a freshman, I was naive enough to bring one. And so my question, and I'm not sure you're going to have this information, but just a little, to lay a little groundwork, I certainly feel for what these burdens are. I mean, I can remember my husband driving all the way down to Las Vegas in a panic because my sister was being charged $100 a day because her sprinkler system wasn't in and she was in a financially tight position. And so not everybody has the ability to call their brother-in-law in another part of the state to come do that work. And so I have a problem with the fines. I have a problem with some of the onerousness of it. But what I'm wondering is this, I think, plays to the whole idea that why in the world are we dealing with HOA issues at the state level? I've long time said this needs to be more at a municipality thing, but here we are. So do we know in the Las Vegas area, I know in the southern part of the state, there's a lot more HOAs than there are here in the north. And I'm in real estate. And so when I'm dealing with buyers, this is a big consideration about where are they going to buy? How can they afford? What can they do? But I don't know in the South, what percentage, do we know what percentage, or could we get that information? What percentage of housing is in an HOA or maybe has CCNRs that are really restrictive like this?
Thank you for the question. I actually don't know. I know that a lot of the new neighborhoods have an HOA. Most of the older neighborhoods don't. And so typically when there's a new development, they typically have an HOA, and some of the municipalities in the planning process and then the planning commission, like they ask the question, like, is there going to be an HOA? And some municipalities want there to be an HOA. I personally don't, just going back to your original comment about it going to the municipalities, I don't know if I'd ever want the municipalities to have control over this because they're squirrely as it is. And I think we would fall into a whole different category of what they believe, think, and what they would fall into. But I don't know. I could probably find out, or maybe somebody is coming in opposition. Maybe they know.
Quickly, please.
Thank you, Chair. And I appreciate that. The reason I bring up the municipality idea is just, I think there would be a far more feedback from homeowners to be able to go to a county commission or a city council meeting versus they're not able to come here and their ability to voice their frustrations. And so that was maybe a thought I had. And yes, if somebody in the room or at some point we could maybe.
We actually do have that answer.
Oh, you do?
We do have that
Great.
answer. And also, I would say that we're also more accessible than our municipalities because we offer the telephones. And so we still are accessible to our Nevadans. And I would also suggest on a personal level, we're going to hear the actual numbers, but ask Southern Assembly members because, in our off time when we're doing some door-to-door work, everyone kind of knows their own district, how many HOAs, how many gated communities, guard gated, and obviously there are trends, but yes, some of us, pretty much everything's a HOA. But we do have the actual response here.
Thank you, Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. There is an article from Nevada Current that came out in January 13, 2025, which states that Nevada has 3,711 HOAs, which represent the owners of 623,917 housing units, half of the state's 1.3 million homes. And that's it.
But like I said, when you break that down per district, you really see the differences. With that, I believe that was our last question, so we're going to go ahead and open it up for testimony. We'll begin here with support testimony for Senate Bill 121 here in Carson City. Again, please remember to state your name and spell it so we have it for the record, and please keep your comments to 2 minutes.
Good morning, Chair, Committee. My name is Zach Bucher, that's B-U-C-H-E-R, representing one of the squirrely municipalities that we referenced earlier. Here in support, even though local governments don't oversee these HOAs, we do receive a lot of calls. We're aware of the problem, so we appreciate Senator Neal addressing this and trying to get ahead of it, and that's why we're here today in support. Thank you.
Thank you. Is there anyone else here in Carson City in support? Is there anyone there in Las Vegas that would like to testify in support? Not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in support of Senate Bill 121, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 121, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I'll open it up for opposition testimony, beginning here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas? Not seeing anyone in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 121, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition, please press star 9 now.
Good morning, Chair and members of the committee. My name is Kimberly Fergus, F-E-R-G-U-S. Okay, I did real estate for over 15 years in Nevada, and I retired in 2016. However, I do have a lot of experience with HOAs and buying, selling, whatever. So I have changed my testimony several times that I don't want to bounce all over the place, but just let me tell you this. When builders build in a community, sometimes per their contract, per their loans, per a lot of stuff, they are forced to have the community with standards like the yards built within a certain amount of time. And then the builders, they own that. They own the land until you have over 25%, 50% sold before an HOA ever takes place. And sometimes, like, when we used to do those apartment conversions into condos, you could never get a loan until you had over a certain percentage of owner occupied and yada, yada, yada. Now I'm going way back because I did this 15 years and I've been retired from it for 10. However, builders, like I said, they own that. They have the rights. So when you're buying a new house and you know what is expected of you to do, you're aware of it. And my advice to you is, it's a little harsh, but you know what, if you can't live up to what the HOA is going to ask, then don't buy in an HOA. I mean, SB 121 erodes
Excuse me, ma'am, your
standards.
2 minutes are up. Thank you. If you have any additional comments,
Okay.
please submit them. Next caller.
Follow with the last 3 digits, 765. Please press star 6 to unmute your phone. You may begin.
Good morning, Chair Miller and members of the committee. My name is Garrett Gordon. I'm an attorney at Womble Bond Dickinson, representing the Community Association Institute, known as CAI. We advocate for homeowners, board members, and
Mr.
professional
Gordon, please
affiliates
spell your name. Mr.
over.
Gordon, please spell your name.
Oh, sure. Last name Gordon, Gordon. Thank you. We advocate for over, as you heard earlier, the 3,700 homeowners associations in Nevada. I apologize for not being there in person. I had a family obligation this morning. CAI did have considerable opposition to the bill in the Senate, but I do want to thank Senator Neal for working with us on the amendment that was mentioned earlier in the hearing this week. Given those negotiations, I have personally asked that the association stand down in their opposition while we work in good faith with Senator Neal. And again, I want to thank her for her consideration. For the record, we are 100% in agreement with Section 2 in that association should never be reporting homeowner information to collection companies. That's absolutely inappropriate, and I appreciate Senator Neal making that change in law. We do still have some concerns about Sections 1, 3, and 5, and hopefully continue to work with Senator Neal and get to some common ground before work session. And finally, I'll just address the municipality question, if I might. So, in fact, when municipalities approve plan unit developments known as PUDs, municipalities really require developers to create HOAs because the HOAs take over responsibility for maintaining the roads, for snow removal up north, for maintaining the parks and playground equipment, for security, for landscaping. And there was a study done years ago that saves these municipalities quite a lot of money. I mean, hundreds of thousands, if not millions of dollars in maintenance obligations that are now shifted to the HOAs and homeowners and taking that obligation off the books. So I really appreciate the time this morning, and Senator Neal, I'll certainly find you next week, and hopefully we can continue working together. Thank you, Madam Chair.
Thank you. Next caller.
Chair, there are no other callers to testify in opposition at this time.
Okay, then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone approach in Las Vegas. Broadcasting, please open the lines.
The public lines are open and working. There are no other callers to testify neutral at this time.
Thank you. Then I will welcome the senator up for any final remarks.
Senator Neal, for the record, I want to thank the Assembly Committee of Judiciary for hearing this bill. And this is my baby toe into trying to go after real covenants. So I will see you guys probably again next session.
Thank you so much. And with that, I will go ahead and close the hearing on SB 121. Next, I will open the hearing on SB 202, which revises provisions relating to real property. And so we are waiting for the senators, or at least one senator. Can someone contact Senator Steinbeck? Senator Stone, are you presenting alone or with Senator Steinbeck? You're presenting alone? Okay, well, then don't call Steinbeck. Tell him. Yeah. Yeah, because he's not on this one. So, oh wait, you're presenting for 202 though, right? We're not on that bill yet. Thank you. Oh, we are on that bill, yeah. Okay, I got him in my hands mixed up. Come on, Senator Stone, we're ready. So I'll open the hearing for 202, and whenever you're ready, please proceed, okay? That's 371.
Good morning, Chair Miller and committee members. Forgive my voice, I'm a little bit under the weather. For the record, I'm Jeff Stone, representing Senate District 20 from Mesquite, including Henderson all the way to southerly to Laughlin. I'm presenting this bill on behalf of Senator Ellison, who could not be here today. As you know, it's a criminal offense to unlawfully enter a residence with the intent to occupy it or another person to live there without the property owner's permission. Additionally, it is considered unlawful occupancy for an individual to reside in a dwelling if they know or have reason to believe that such a residence is unauthorized by the owner. Senate Bill 202, as amended, expands these provisions to address situations where an individual presents or uses a false or forged rental agreement to allow someone to break into or occupy a dwelling. The key element here is the intent to establish residency either for themselves or another person. This bill is designed to prevent unauthorized occupation of properties, regardless if they're empty or temporarily uninhabited. The bill also revises timelines related to someone's ability to contest an eviction and how long the owner of the property must store the personal property of someone who's been evicted in an instance of an unlawful occupancy. The bill provides clear guidelines for law enforcement and property owners. Section 1 revises provisions related to housebreaking to include using a false or forged written rental agreement to gain access with the intent to live in a dwelling or let someone else do so. Section 2 also expands the crime of unlawful occupancy to make it unlawful to take up residence in a dwelling if a person knows or has reason to believe that such residency is without permission of the owner of the dwelling or unauthorized representative of the owner. Section 2.3 provides definitions for the terms squatter and tenant for certain purposes relating to summary proceedings for obtaining possession of real property, a recreational vehicle, or a mobile home, and clarifies that a squatter is not a tenant for such purposes. Section 2.5 reduces from 21 days to 5 days a period for which an unlawful or unauthorized occupant who's been locked out of a dwelling has the right to contest the matter by filing a verified complaint seeking reentry, and the time the owner of the dwelling is required to store the personal property of the unlawful or unauthorized occupant. Section 2.7 clarifies the process by which an unlawful or unauthorized occupant has been locked out may seek the return of his or her personal property. Thank you, Madam Chair, and I'm happy to answer any questions.
Thank you so much, Senator. With that, we do have a question from Assemblymember Roth.
Thank you, Chair, and thank you for the presentation. My question is in regard, you said that the intent is to prohibit someone from establishing residency for themselves or another person unlawfully. And I think that's a little bit of a sticking point for me, especially when we're looking at somebody subletting, and the person who is subletting then unknowingly enters into some sort of false agreement. They're not aware of that. So can you speak to that intent a little bit, and especially with the definition of squatter, does that apply to somebody who would unknowingly enter into some sort of subletting situation?
Thank you, Senator Roth, for the question. I actually had kind of a personal experience with this in one of the units that I have, where I had an elderly couple that had a son, and they had requested, the elderly couple, that the son be allowed to live there, and I said that would be fine. We amended their lease to such an effect. And then the son came up with false leases and actually ended up leasing out to 3 or 4 more people, and actually almost forced out the elderly people from living there. And so I had to go through the complete eviction process, and unfortunately, not only did the squatters, if you will, become evicted, but also the elderly couple, unfortunately, was evicted as well.
So to clarify, this would include somebody who is unknowingly subletting, would be considered a squatter and thereby subject to criminal penalties.
They would be a squatter if they originally were given a lease, a fraudulent lease, for example, and unknowingly signed that lease and became a victim, if you will, of the person that did the fraudulent lease. And then it became apparent to them when the owner came forward and said, "This is not this person's property. This is my property." If they continued to stay, knowing that they didn't have authorization to be there from the owner, then they in fact would be a squatter, because they knowingly knew after the fact, if you will, that they did not have permission from the original owner to stay in that unit.
I don't see a knowingly provision in here under the definition of squatter, and that is where my concern is.
Notwithstanding any other provision of the law, the term includes with this definition of squatter without limitation a person who enters onto or intrudes upon real property without the permission of the owner and continues to occupy the property without title, right, or permission of the owner or authorized representative of the owner. So they continue to occupy, knowing that they did not have a valid lease or permission from the owner to occupy the unit.
So I have a question, and I want to bring it to the opposite side of that. So we're talking about leases, and obviously it's already criminal to create a fake lease or try to lease or sell something that you don't have the legal rights to. But in those situations when we're talking about someone living on someone's property, what about protection for those arrangements when there is no legal, no documented proof of an agreement? It could be as even, someone letting their brother-in-law live in their camper or their boat, and you can park it on my property. I own the property, and that's just the family agreement. He's lived out there. His camper's been parked out there for years on my property. Would there be protections in those situations for those people? Because while we may have definitions of squatters and things like that in this bill, because what triggered me is seeing the words recreational vehicle or mobile home. So wanting to protect those individuals who a recreational vehicle, mobile home, a boat, a whatever is actually their home. And so would there be protections in those situations for those individuals?
Senator Stone, for the record, yes, I believe there would be protections. Obviously, if somebody goes into a mobile home unlawfully, the owner of the mobile home could go through the traditional eviction process.
I'm trying to protect them from the eviction process.
Right.
That's what I'm saying. If they've been giving permission to live there, yet there's no written documentation, there's no lease, there's no anything to prove it, it's just been a friend or a family agreement. Are they protected? Is this still considered their home?
I believe that it is, and would certainly be adjudicated through the courts if necessary.
Okay, thank you so much. Let's see. I believe that's all the questions we have a question from Assemblymember LaRue Hatch.
Thank you so much, Chair. So my question is on sections 1 and 2, the addition of this new language. I'm trying to get a better sense of what differentiates these, because under the original law, I think it makes sense, right? If somebody enters forcibly into an uninhabited or vacant dwelling, they're guilty of housebreaking, right? If somebody in section 2 takes up residence without permission, they're guilty of unlawful occupancy. But now in both of these, we've added the same language with an or statement, right? So if you enter a vacant dwelling or you intentionally procure a false or a forged written agreement, and in the other one, or you intentionally procure a false agreement, that or statement makes it seem like we have the same crime twice. And so how do I know which one you would be charged with? Because it's not an and, it's an or. Does that make sense? I can explain again if you need. So my question is in section 1, sub 1, right? You can be charged with housebreaking if you enter an uninhabited or vacant dwelling, or if you get a false written rental agreement. So either one of those, you would get charged with housebreaking. But in section 2, if you take up residence without permission, or you get a false written rental agreement, you're now charged with unlawful occupancy. So if somebody got a false or forged written rental agreement, are they going to be charged with both unlawful occupancy and housebreaking? That's my question.
Thank you, Senator LaRue Hatch, for the question. I believe that the person that's in the unit who's there unlawfully because they signed a lease agreement that was fraudulent is not going to be accused or prosecuted for unlawful breaking in entry, if that's the gist of your question.
Yeah, no, and that is the gist of my question. I'm just wondering what is going to prevent that, because all that requires is that they have a false agreement and then they qualify under this section for being guilty of housebreaking.
They would be guilty of housebreaking if they were the ones that broke into the house. They're the ones that had the fraudulent lease agreement. If somebody is the beneficiary of a false lease agreement and it's been brought to their attention by a property owner that their lease is invalid, that they would not be held accountable for housebreaking.
And Chair, maybe we could just at some point get some clarity from legal. If I may be misreading it, I just want to make sure we're not creating duplicate crimes in two sections.
Carly O'Krent for the record. It seems to me as if the crime for which a person would be prosecuted would be a matter of prosecutorial discretion. But in Section 2, the disjunctive rather than the conjunctive reading, I think, might be slightly off, at least from what I'm hearing from your perspective. But as with respect to Section 1, I think, if a person forcibly enters, that's different than the latter situation. And so the prosecuting attorney would determine based on the facts of each individual circumstance which applied.
Okay, and with that, we will go ahead and open it up for testimony, beginning here with support testimony here in Carson City.
Good morning, Chair, members of the committee. My name is Joshua Martinez, representing the Las Vegas Metropolitan Police Department. We're here in support of SB 202 today. This current law allows for law enforcement to take action on the unlawful occupancy of a residence. Actually just worked with some members of our community, reference a vacant home, a home that's an issue within a residential area, and we were able to go in and charge a person currently with unlawful occupancy. What I think this is going to do too and help clarify is in Section 2, reference the new language when a person procures or offers a false or forged written rental agreement, which you do see often, which, that could be covered under forgery as well with current laws. But this would help clarify a little bit as well, because what you see is properties being offered up on the internet or Craigslist or any other platforms that are out there today, and then a person will forge the document or go down and create their own document to when they locate a house that they know is either for sale or vacant or hasn't been lived in for some time. So this would help clarify some of that, and then we're in support of this bill. Thank you.
Good morning, Chair Miller, members of the committee. For the record, my name is Taylor Avery, Taylor-Avery, and I'm the Manager of Political Affairs for the Vegas Chamber. The Chamber is in support of SB 202. The bill defends small property owners from fraudulent activity and ensures that homes are not taken advantage of by bad actors. This bill expands laws against the use of fake rental agreements, which is a needed update to address evolving methods used by squatters and scammers. The bill supports much-needed housing stability by giving landlords tools to protect their properties and return them to the market quickly for Nevada's families. We'd like to thank the bill sponsor for bringing the bill forward. Thank you for your consideration.
Thank you so much. Is there anyone else here in Carson City in support? Not seeing anyone else. Is there anyone in Las Vegas in support? Yes, please come forward.
Good morning, Chair Miller and the members of the Assembly Judiciary Committee. My name is Paul Rich, R-I-C-H, and I'm here on behalf of the Nevada Realtors. The issues of squatters have been an issue in Nevada for some time. However, the impact of these unlawful acts has become more frequent and more impactful for property owners. The changes to allow for a crime to be charged against those who create or procure a false rental agreement is an important step to highlight that these actions are a crime. The new definitions of a tenant and squatter to highlight the differences between these groups is important to ensure that the changes proposed in the bill will not impact the rights of legal tenants. The shortened timelines from 21 down to 5 calendar days for removal of squatters and timelines for any of their personal property to be held or retrieved help ensure that legal property owners are supported and reduce the burden on these victims. We ask that you support SB 202 to help address these crimes and enabling property owners to regain custody of their property. Thank you for your time.
Thank you so much. Not seeing anyone else there in Las Vegas wishing to testify. Broadcasting, will you open the lines?
If you would like to testify in support of Senate Bill 202, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 202, please press star 9 now to take your place in the queue.
Good morning, Chair and members of the committee. My name is Kimberly Fergus, Fergus. I rise in strong support of Senate Bill 202. This is a long overdue legislation, gives property owners, law enforcement, and our courts the tools to address the growing crisis of squatting and fraudulent occupancy. Fake leases and loopholes. For far too long, bad actors have used phony rental agreements to game the system, delay eviction, and create chaos for homeowners. SB 202 makes it a crime to procure or offer a false lease, a critical step to shutting down fraud and protecting legal tenants. Squatters are not tenants. This bill draws a clear line. A squatter is not a tenant. No more abuse of tenant rights by individuals who never had legal occupancy. That's justified for real tenants and landlords alike. Number 3, restoring property rights quickly. SB 202 reduces the window for unlawful occupants to contest lawful lockouts and limits how long owners must store abandoned property. And it's been said earlier, so I echo a lot that's been said. This protects property owners from ongoing harm and stops the financial drain of housing individuals who broke it illegally. This bill is not about denying housing. It's about defending property rights, restoring the rule of law, and ending the free-for-all that squatters and their enablers have exploited for far too long. I urge you to pass SB 202 and send a message. Fraud, forgery, and illegal occupation will not be tolerated in Nevada. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in support at this time.
Thank you so much. Then I will move to opposition testimony beginning here in Carson City.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. No one likes squatters, but it's generally the people on the margins that get tricked. Like, they're meeting somebody through Facebook Marketplace, they'll give them a fake lease, and they're the ones that become the victims at that point. We do have concerns about the definitions on here for squatters and tenants. Because all it would really take is for a landlord to just falsely brandish somebody as a squatter. Unlawful occupancy is a gross misdemeanor. This body has already done good work on that. But our main concern here is the reduction from 21 calendar days to 5 days in Section 2.5 to contest whether someone is actually an unlawful occupant. We want any homeowner to be able to remove squatters from the property as fast as possible, but we also know that there are some landlords that are not the best actors and can use this process to get a lawful renter out faster. The 21 days gives both sides a chance to put forth their rights to being on the property.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. Just to continue on a little bit from what Clark County PD just stated, 5 days is just not enough time when you have that innocent person who doesn't understand that the lease is not legal for them. And listening to the presentation, they said when the landlord or the owner comes and tells them that the lease that they have is invalid, did that person still only get 5 days to remove their life that they didn't know about? They didn't know, and now they have 5 days to remove all their personal property. And with this bill, there seems to be no notification by the landlord or the owner to this innocent person. So when you address them, is there some kind of form they can give them that say, hey, you have this timeline to go down to the court and start this process if you need more time or if you think that I am being unreasonable? I think there needs to be a little give and take here. So I think the 5 days is too long. And I think there should be some notification by the landlord to this person that they are trying to kick out, especially if they are an innocent person. Thank you.
Chair Miller, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. Didn't have an issue with this bill in the first house, but the definition of squatter and then the presentation today makes it unclear to me if someone who is an innocent renter who was conned by a fraudster has moved their whole family into, say, a 3 or 4 bedroom house. Are they a squatter once the landlord comes and or the owner of the property comes and says, "This is my property," and where are they relative to their rights there? And if you think about the timeline to move a house like that, and that person would be, have lost their security deposit, any last month's rent would be gone, right? Also, the subletting situation that was brought up. We've had scam artists in Clark County rent multiple houses and then sublease individual bedrooms without permission from the property owner. Are they going to be in the position of being a squatter once they're on notice that this is not, that the person didn't have the right to enter into that agreement? And then just also generally an oral lease where, leasing agreement with, where the person's paid cash and hasn't gotten a receipt, will they be in the same position if an unscrupulous landlord wants to get them out? How are they going to show evidence that they're a legitimate tenant? And I think it goes back to, how do people know who has the legitimate authority to rent a property? This is a systems issue, and a systems solution is having a landlord registry run by the state government or local municipalities where any tenant can look up any property and know exactly who they should be speaking with. This fraud is allowed to persist because you have vacant properties and people are able to take advantage of that. If every person in Nevada could look up who is responsible for each individual property, and I know people can say silver flume, that's only if they have a business license. It's very hard for people to navigate. So I think that's a system solution to this problem that would protect landlords and protect innocent tenants. Thank you.
Thank you so much. Is there anyone else in opposition here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 202, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 202, please press star 9 now.
Good morning, Chair Miller and members of the committee. My name is Ben Innes. That is BENINESS. I am the coalition manager for the Nevada Housing Justice Alliance. We are a statewide coalition of grassroots organizers, community advocates that fight with tenants for meaningful and lasting tenant protections so that folks can stay stably housed. Calling in opposition to this bill, I think the growing anti-squatter sentiment is a bit of a scapegoat for the real large bad actors in our state's housing crisis, which is the corporations that are cannibalizing our communities and neighborhoods. But more specifically, calling in to ensure that everyone's collective efforts on this bill reduce any unintended consequences. Much of these have been touched on by a lot of my peers already. And it speaks to that situation that I believe Mr. Norman spoke to. And we saw this throughout 2024 with our eviction court watching program throughout the Las Vegas Valley. And so the situation is where, again, to reiterate, tenants have taken occupancy due to fraud perpetrated by, fake implicitous landlords. In these cases, tenants have done nothing wrong. They've signed what appears to be a valid lease. They've been paying bills and have often even moved utilities to their names as well. So the current language doesn't capture the possibility that the tenants may be as much victims as the true landlord. We wouldn't want to see those victims suffer these collateral consequences of being labeled squatters, and really suggest a simple and small amendment to consider such cases, so no one has to be, fall victim to that 5-day timeline. So thank you, Chair. Thank you, Senator Stone. Take care.
Thank you. Next caller.
Good morning, Chair. Good morning, Chair Miller and members of the committee. My name is Tara Webster, TARAWEBSTER. I'm the policy manager for the Progressive Leadership Alliance of Nevada, calling in opposition to Senate Bill 202. This proposed legislation fails to really address the ongoing housing crisis, the need for affordable housing, or protection of tenants' rights. Instead, it really appears to be motivated by an unsubstantiated fear that individuals are en masse taking up residence in empty homes. Our worry at Plan is that the language in SB 202 unfairly targets and penalizes tenants. This bill overlooks bad actors and unethical landlords who are renting and subleasing properties without ownership or proper rental permits. These landlords might attempt to bypass standard eviction procedures by falsely labeling tenants as squatters to remove them from their homes. Tenants have rights, and we must continue to work to uphold and strengthen those safeguards. And with that, we urge you to vote against Senate Bill 202.
Thank you. Next caller.
Good afternoon, Chair and members of the committee. For the record, my name is Erika Castro, ERIKACASTRO, and I'm here in strong opposition to AB 201 on behalf of the Nevada Immigrant Coalition. At a time where we are seeing increased xenophobia and targeting of immigrant communities, we are deeply concerned this bill could be used by bad actors to target immigrant tenants and their families. Many immigrant community members can often fall victims to fraud due to their status or language barriers. Under this bill, an abusive landlord could merely allege that the tenant is a squatter or occupying the premise under a fraudulent lease to then take advantage of the fast-track eviction process, even leading to criminal charges. We urge you to oppose this bill and not further criminalize tenants or immigrants in our state. I also want to echo Mr. Norman's sentiment that this is a system issue, and having a landlord registry could help avoid fraud and ensure we have a stronger rental process for all involved. Thank you.
Next caller.
Chair, there are no other callers to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone here in Carson or in Las Vegas. Broadcasting, please open the lines.
Chair, the public line is open and working. There are no other callers to testify in neutral at this time.
Thank you so much. Then I will welcome Senator Stone back up for any final remarks.
Thank you, Madam Chair. On behalf of Senator Ellison, thank you for hearing the bill, and we're very happy to work with the opposition on some of the valid points that they brought forward. Thank you very much.
Thank you. And with that, I will go ahead and close the hearing for Senate Bill 202. Next, I will open the hearing for Senate Bill 371, which revises provisions relating to crimes. And so, Senator, your bill hearing is open. Whenever you and your co-presenters are all settled, you may proceed.
Good morning. Thank you, Madam Chair Madam Chair Miller. I appreciate this opportunity, and thank you, committee members. For the record, I'm John Steinbeck. I'm representing Senate District 18 in Clark County, and I appreciate this opportunity to present Senate Bill 371 today, which revises provisions relating to crime. I would also like to add that Senator Fabian Donate is a co-sponsor of this bill, and that Mr. Nick Vasiliadis is presenting with me here today. Senate Bill 371 was amended from its original text before passing the Senate. Last session, the Nevada Legislature passed SB 412, which added a look-back period for trespass warnings. Any person who willfully goes or remains upon any land or in any building after having been warned during the previous 24 months by the owner or occupant thereof not to trespass is guilty of a misdemeanor. This bill we are presenting today will extend the look-back period from 24 to 36 months. The Nevada economy is still and always will be heavily reliant on our tourism. It is what we do the very best in the world. This bill is intended to increase our safety and security for our visitors and our amazing workers in our resorts. Crime committed in our resorts not only affects the direct victim, but threatens the livelihood of all Nevadans. I would now like to turn it over to Nick Vasiliadis for additional information.
Good morning, Chair, Vice Chair, members of the committee. My name is Nick Vasiliadis, representing the Nevada Resort Association. I'm honored here to be here with Senator Steinbeck to help present SB 371, and I would also like to thank Senator Dinante for signing on to this bill. After more than 30 years with Clark County Fire Department, nearly 5 years as chief, Senator Steinbeck knows almost better than anyone the situations firsthand first responders and law enforcement face every single day and night in our state's tourism districts. And his experience has been invaluable in providing insights on why this legislation is necessary. Together, we'll explain why Senate Bill 371 is critical to ensuring the safety of the 366,000 Nevadans at work in leisure and hospitality across the state, nearly half of whom work directly in hotel casinos. There's no higher priority for the resort than safety. Resort employees want to feel safe at work while walking to and from their workplaces, to their cars, to their ride homes, a feeling that's essential to their well-being. Safety is also vital to the industry's efforts to attract and retain talent. And I know it's a reality this body knows all too well, but the industry is always one bad headline away from causing economic strain in the state of Nevada. I'd like to make it abundantly clear that Las Vegas Metropolitan Police Department, the Reno Police Department, and many local, state, federal law enforcement partners are doing an excellent job at keeping tourism districts safe. The resort security teams work closely with law enforcement and act as a force multiplier in having a visible and effective presence to deter criminal activity and protect team members and guests. Further, we appreciate the important role the District Attorney's Office plays in prosecuting these offenders. However, there remains those that are not deterred, and despite all our collective best effort, they continue to perpetuate crimes. Over the past few years, the resort industry has worked with law enforcement, district attorneys, and local jurisdictions to address recidivism in resort areas. And while strong tools have been put into place, SB 371 adds another necessary layer to stop chronic trespassers who repeatedly commit crimes in tourism areas despite being trespassed or arrested over and over again. This legislation will update NRS to extend that trespassing look-back period from 24 months to 36 months. Why 36 months, you might ask? Our experience over the past 2 years shows that 24 months is simply not enough time to provide a complete picture. Increasing the time frame allows law enforcement, prosecutors, the courts, resort security to identify specific patterns of behavior by chronic offenders and make more informed decisions in terms of consequences, including the appropriate charges and sentencing needed to end this repetitive cycle. Law enforcement and resort security have witnessed firsthand a person trespass at one location, move to another location down the street, continue illegal conduct there until they're caught there, and continuing this process over and over again. And further, if a person is not convicted, they're simply not subject to the order out corridors. We know from practical experience that they will return to continue their activity. And oftentimes when this activity goes unchecked, it tends to increase behavior, oftentimes escalating into felonies. And it cannot be overstated how this becomes a morale blow to our employees, to guests, but specifically employees, when they see the same pattern of behaviors going on and just completely going unchecked. And so, given that SB 371 will address those circumstances where habitual offenders slip through the systems, committing crimes unchecked, we think that there is a lot at stake with this bill, and we would urge this committee's support, especially as we face kind of volatile and uncertain economic times on the horizon. Please keep in mind as you consider this bill that the tourism district are workplaces for hundreds of thousands of Nevadans, and that this industry is the economic driver of that state. We believe this is a common sense effort and measure that you can support, and I thank you for the opportunity to speak in front of you today, Chair. Thank you.
Thank you, Madam Chair. John Steinbeck again for the record. We stand ready for any questions.
Thank you. And Thank you for your first presentation here in Assembly Judiciary. With that, we will begin questions. Our first one will be from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. If you could just provide some clarity, I believe last session we established that 24-month period as a look back. And correct me if I'm wrong, but what I heard the testimony was is that that wasn't enough time to establish a clear pattern or a full picture. So what data do we have that suggests that moving it from 24 months to 36 months is necessary? Do we know how many people have been removed and then have returned in the last 2 years?
Chair Nick Vassiliadis, for the record, through you to thank you, Chair. Assemblyman Roth, for the record, we'll try to get you exact numbers, but we also believe that this raising it from 24 to 36 months brings it in line with several other statutes, such as DUIs. And so if you were looking for specific data, we can get that back to you, but we do believe this brings this in line with other elements of NRS.
Can you clarify that with the DUIs? I don't believe there's any 2-year look-back period for DUIs.
Yeah, I'll find that for you and I'll bring that to you.
Assemblymember LaRue Hatch, do you have a question? Okay.
Thank you so much, Chair. Thank you for joining us this morning. So my question is about when this law went into effect, and now we're looking at changing it. I don't have the date of when it originally went into effect, but I would imagine it wasn't May 2023. I would imagine it was probably July or January after. So it hasn't been 24 months of this being in effect. So my question is, how do we know this is not working when we haven't actually even gone through that whole time period yet prior to altering it again?
Assemblywoman Serena Lewis Hatch, Nick Vassiliadis, for the record, on behalf of the Nevada Resort Association. This came from the guidance from our security teams and law enforcement professionals in working with the community that we think this just provides us better context in terms of those habitual and repeat offenders.
You know, and I appreciate that. I'm just wondering what you're basing that on, I suppose. Are people not listening and they're being kicked out and then they're just coming back immediately? And if that's the case, how does 36 months help? And if that's not the case, what is it that we're basing this change on?
I think like Assemblywoman Roth, I would like to follow up with you on that specific answer, if that's okay, Assemblywoman.
Did you want to respond? Okay.
Just waiting for the next one, ma'am. Thank you.
All right, here it comes. So my question is, and again, I remember the bill from last session, excuse me, and looking at it now, and of course with this conversation, and it just says building upon any land or any building. And so we're hearing this from the perspective of the Resorts Association and business and tourism. However, a building is a building, and we have many, they don't get advertised, but it happens more than people think in our public buildings. When we're talking about the assaults and challenges and the number of people that need to be trespassed for everyone else's protection from schools, from, hospitals are both public and private, but we have schools, we have hospitals, we have other public buildings where people have been trespassed. Will they be included in this bill?
John Steinbeck, for the record, I believe so. I guess that would be a question best for legal. Unfortunately, while I'm bringing this bill forward, I'm not an expert on the history of it or exactly on everyone it'll pertain. Maybe Nick can answer that, and then maybe legal can answer that, but I believe so, ma'am.
Nick Vassiliadis, for the record, yes, Chair, it's our understanding that it would apply broadly in that sense. This was a discussion that took place on the Senate side, and I think the industry was initially okay with limiting to just resort hotel corridors and resort properties. However, senators on the Senate side showed an interest in having supply to all businesses because trespassing and repetitive trespassing is an issue for many businesses, not just the resort corridors.
Okay, so are you saying that that was part of the sections that were amended out? Because you're saying you wanted to limit it to just the resort corridor. I'm saying I'm concerned about our public facilities. The senator is saying he believes it covers, and then now you're also stating that it would be more than just the resort corridor, but all businesses, because these concerns happen everywhere. So which is it? And is that what was initially intended but was since amended out?
I'm sorry if my answer was confusing, but no, I think our answers align in that it would apply broadly to all businesses. That I was just more stating that the industry was not opposed necessarily to having a more limited view, but through conversations in the Senate, it appeared that senators would have preferred to have this apply more broadly versus very specifically, because trespass is an issue more than just resort areas.
Okay, and I'm asking because it is an issue more than just resort areas, about our public facilities and our public employees.
I would defer to legal if it would apply to public employees, public buildings.
Carly Okrent for the record. I think, if you're going upon, there is no limitation that's prescribed by the bill. So I think in answer to your question, yes.
Which, Madam Chair, is good news, because those facilities deserve, and those employees and the people in them deserve every bit as much protection.
Thank you so much. And you, of course, with your professional background, understand that. It's just a point I don't think that we stress enough here. So thank you for that, Senator. We also do have the date that the bill went into effect was July 1st, 2023. So it hasn't been quite 2 years yet, and I think that's what my colleague was asking about when it went into effect. With that, I don't see any additional questions, so we're talking about the last bill. So I will go ahead and open it up for support testimony, beginning here in Carson City for Senate Bill 371.
Good morning, Chair and members of the committee. My name is Joshua Martinez, representing the Las Vegas Metropolitan Police Department. Just want to say we're in support of this piece of legislation. It'll give us the opportunity to deal with the repeat offenders that we see, as you said, Chair, not only in the resort corridor, but also at other buildings and businesses throughout our community. Thank you.
Good morning, Chair, Vice Chair, members of the committee. My name is Wesley Harper. I am the Director of Government Affairs for the City of North Las Vegas. We believe that this helps to bring safety to all workers and people that occupy buildings within our city, and therefore we are in support. Thank you.
Good morning, Chair Miller and members of the committee. Kanani Espinoza with the Rowe Law Group on behalf of Boyd Gaming Corporation. We thank Senator Steinbeck for bringing this measure. Would like to echo the comments of the NRA with the presentation by Nick Vasiliadis. We support SB 371 as the safety of our guests and team members are of utmost importance to us, and this gives law enforcement an additional tool to be able to deal with the repeat offenders. Thank you.
Good morning, Chair, members of the committee. Daniel Stewart. On behalf of Wynn Resorts, we'd just like to say ditto. We support the bill. Thank you.
Anyone else here in Carson City? Not seeing anyone here in Carson or in Las Vegas. Broadcasting, please open the lines.
If you would like to testify in support of Senate Bill 371, please press star 9 now to take your place in the queue. Again, if you would like to testify in support, please press star 9 now.
Good morning, Chair and members of the committee. My name is Kimberly Fergus, Fergus. I rise in strong support of Senate Bill 371. I echo what everybody else has said. However, to me, this bill makes a small but meaningful change, extending the period of trespassing warning remains valid from 24 months to 36 months, and it's long overdue. Right now, under NRS 207.200, a property owner must reissue a trespass warning every 2 years just to protect their own land from repeat offenders. That's an unnecessary burden on landowners, business, and law enforcement. SB 371 simply gives property owners more time, 3 years instead of 2, to act on prior violations without restarting the process. This matters, especially in rural areas or in cases where individuals repeatedly test the boundaries of the law, knowing prior warnings expire too quickly. It also means law enforcement officers don't have to re-verify the timeline every 2 years to enforce an otherwise valid trespass. This saves time and money and resources. Let's be clear, this bill does not expand criminal penalties. It strengthens an existing law to better protect property owners and occupants who follow the rules, post proper signage, maintain fences, and issue lawful warnings. Nevada has seen rising issues in unlawful entry, squatting, and property abuse. This bill gives landowners more certainty, and it tells would-be trespassers that warnings carry weight. I urge you to pass SB 371 and stand with property rights, common sense, and law enforcement. And thank you.
Thank you. Next caller.
Chair, there are no other callers to testify in support at this time.
Thank you. And so I see 3 individuals down in Las Vegas. Are you in opposition or support?
Support.
Okay, then we will go back to Carson City for support testimony. Please proceed. You know what I mean. Las Vegas, please proceed.
Thank you. My name is Virginia Valentine, and I am Valentine, and I am here to speak in support of SB 371 on behalf of the Nevada Resort Association. Good morning, Chair Miller, Vice Chair Marzola, and committee. I'd like to thank the bill sponsors, Senators Steinbeck and Donate. As you heard from their presentations and Mr. Vasiliadis's, employee and guest safety are our top priority for us. We strive to create a safe environment for our team members and our guests. This bill is important to reduce recidivism by identifying and deterring employees trespass for crimes against people and property. I do wish we had more data for you. The security chiefs and the properties see repeat trespassers. They've seen it increase. Unfortunately, we do not have data from the courts. We do have some data from Metro, and we look forward to providing you with that. This bill is important for reducing recidivism by identifying and deterring individuals who have trespassed for crimes against people and property. Yesterday, the Economic Forum forecasted challenges ahead for the state and the tourism industry. It is more important than ever that we have every possible tool to prevent repeat offenders from returning. This tool should help by identifying repeat offenders who move from property to property and between jurisdictions. That means in addition to deferring repeat offenders, we're training employees to identify and assist victims of human trafficking, and we are working very hard to fulfill our commitment to the state and local governments in our partnership to complete the Campus for Hope, which will provide 900 beds for transitional housing of the unsheltered in Southern Nevada. In closing, we support SB 371. It will help defer repeat offenders and assist in keeping destination for employees safe for employees and guests. Thank you so much.
Thank you. Next.
Good morning, Chair Miller and members of the committee. My name is Jason Gray, G-R-A-Y, Vice President, Government Affairs for MGM Resorts International, here to testify in support of Senate Bill 371. At MGM Resorts, our highest priority is the safety and security of our team members and guests. With approximately 45,000 team members based in Las Vegas who spend on average 25 to 30% of their daily lives with us, we are dedicated to creating an environment where everyone feels safe and protected. We are equally committed to providing a safe and enjoyable experience for all of our guests. Public safety at resort hotels and tourism assets is of existential importance to our destination and to the state. It's crucial that our visitors continue to view Las Vegas as welcoming and safe. Relative to SB 371 specifically, as has been stated, we face ongoing challenges with repeat and in some cases, habitual trespassers whose conduct over time can escalate in severity and consequence, underscoring the need for more effective measures to address and prevent unlawful behavior to ensure the safety of our team members and our guests. Extending the look-back period to repeat trespassers not only enhances our ability to address security challenges more effectively, but also provides our partners in the justice system with a longer window with which to assess patterns of behavior, which will substantively inform their decisions relative to charges, sentencing, and rehabilitation. Put simply, this helps everyone involved understand how long we've had issues with specific individuals, allowing for more informed decision-making relative to habitual offenders. This bill will help create a safer environment for our team members, guests, and the broader community. We thank Senators Steinbeck and Doñate for their sponsorship, respectfully urge your support, and welcome and encourage continued dialogue on policy measures to improve public safety throughout our community, including in areas of highly critical economic activity. Thank you.
Thank you. Next.
Good morning, Chair Miller and members of the Judiciary Committee. Carlos Arlesane II, for the record, that's L-A, capital S-A-N-E, Vice President of Government and Community Affairs for Caesars Entertainment. It's always an honor and a privilege to have the opportunity to testify before the legislature, particularly in support of the thousands of employees that work in the gaming and hospitality industry and the millions of guests who choose to come to Las Vegas, the entertainment capital of the world. I'm before you today to ask for your support for SB 371. Our employees should be able to work in an environment that's safe and not have to worry about being assaulted in a stairwell or while cleaning a guest room or having their tips stolen from them during their shift by habitual offenders. And our guests should not have to worry about their safety when visiting us. Simply put, crime is a significant issue on the Strip and at our surrounding resorts and at our public buildings. We need to do all we can to protect our employees, our guests, our citizens, and our reputation is on the line. Over the last few years, Caesars Entertainment has spent close to $10 million at our properties to enhance security measures for the protection of team members, providing personal panic alarms, a shock detection system. We share with the Metro Department and a facial recognition and weapon detection technology. The tourism industry is the financial lifeblood of Nevada. We need to do all we can to protect our citizens, employees, and our guests. I urge you to support SB 371, and a huge thank you to Senators Steinbeck and Doñate for their support. Thank you for your time.
Thank you. Is there anyone else down in Las Vegas wishing to give support testimony? Okay, then we will move to opposition testimony, beginning here in Carson City.
Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. In 2023, in Las Vegas, we created a special court called the Strip Corridor Court, where if any offense was committed on the Strip Corridor, it went in front of 2 judges. I practiced in that courtroom for over a year, and that courtroom was dissolved in November of 2024. But that courtroom, along with a new crime called a violation of the order out, created a cycle of incarceration for mostly our in-house population. What happened is that people would be charged with mostly misdemeanor offenses, like trespass, and then they would be ordered to stay out of the Strip for about 6 months. And if they were found on the Strip, you would be charged with a new crime for a misdemeanor called violation of the order out. But again, most people were unhoused. And as some of you may know, and if you don't know, we have a huge population of our unhoused people in Las Vegas that live in the tunnels under the Strip. And those entrances to those tunnels are on the Strip, so people would often still be found on the Strip and then be brought into jail. And again, it created the cycle with that people would just be incarcerated for longer and longer and longer times. And because we also have no resources or treatment options for people, we created a cycle without giving people a way out. 2 years for trespass is already a really long time, and at this time we simply can't afford to make changes without research or evidence that will actually improve public safety and will only serve to incarcerate more people.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA KNOTT, testifying in opposition to SB 371. During the presentation and the comments, we heard a lot about repeat offenders or habitual trespassers. I'm concerned that we don't have enough time with this 24-month rule to determine how many people are waiting the 24 months plus 1 day before they trespass. These repeat offenders or habitual trespassers are not waiting 24 months. They are already trespassing within that 24-month time. If they are arrested for trespass within that 24 months, their 24 months starts over again. It is not like they can have as many free trespasses in that 24 months. If they trespass after 6 months, the 2 years starts over again, and they have another 24 months to maintain off the property. For those reasons, we are in opposition. Thank you.
Thank you. Is there anyone else in opposition here in Carson? Is there anyone there in Las Vegas in opposition? Not seeing anyone. Broadcasting, will you please open the lines?
The public lines are open and working. There are no callers for opposition at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone. Is there anyone in Las Vegas that would like to testify in neutral? Also not seeing anyone. Broadcasting, please open the lines.
The public lines are open and working. There are no other callers to testify in neutral at this time.
Okay, thank you so much. Then I will welcome the presenters back up for any final remarks.
Thank you, Madam Chair Miller. John Steinbeck, for the record, I would like to respond to some of the opposition,
Yes,
if
please.
allowed. So it was mentioned about the drainage channels that are underneath the strip, and there are people that live under there. It's very sad. They live under there. They live throughout drainage channels throughout Clark County, and way too many of them. Unfortunately, I'm familiar with every inch of those channels. You don't access those channels from the strip properties. That is not accurate. You access those from public areas that are off strip. And then they do go down into there, but they do not open up and onto the properties. There are some areas that are very close to the rear of one property in particular, but that is not accurate. And then it goes a long ways up underneath this strip corridor, which is all underground. So they're not. What I want to make sure is understood. It's not like people have to access into the drainage channel and then they're on a strip property, get a trespass warning, and then have to go back in there just to be covered from the sun or to be protected. Those are all quite a ways off of all of our resorts. I've rescued everybody underneath there from when the rains start, and then had to pull them out many times, and then also go under there when there's medical issues and unfortunately other crimes that have occurred. But also over the specifically over the last 10 years, I've spent a huge amount of my time making sure that our resort corridor was safe for our normal days and then also for our large events. And so that's been working closely with law enforcement, every other public agency, and of course all of our resort properties. A continuous theme has been that it is the same people that they have the same problems with all of the time, and that is their main safety concerns. And that they are also the issue is that they escalate. Right, and that we get to a point where it goes from minor offenses to escalating, and that's the properties and the security personnel. That's their concern, right? Is that they want to keep the employees safe, they want to keep our visitors safe, and they want to make sure that that people that mean them harm are kept away. Now to Assemblymember LaRue Hatch and Assemblymember Roth, I do commit to try to come with some data if it exists. Again, most of what I know about this particular issue is testimony from the people that do the planning and that provide the security and the law enforcement. And then I'll ask Nick if he has anything else to close.
Chair, thank you for allowing us to present this bill. I think the only thing we'd like to put on the record is it's not the intent of the industry to just arrest and prosecute the unhoused. I mean, I believe last session the industry committed a substantial amount of private capital to build a state-of-the-art facility that would help the unhoused get into better situations and help break what other situations they're in, or even the cycle of addiction. And so I just want to make clear that our intent here is not to just throw the unhoused in prison. Our intent here is to go after those repeat offenders and those habitual trespassers that, when gone unchecked, it does escalate into more dangerous behavior for both employees and for guests. Thank you, Madam Chair.
Thank you. And I am requesting the data on these increased occurrences of people re-trespassing, whether it's the same person coming back over and over in the same building or going to different buildings. We heard in testimony these increased occurrences. And also if there is any data to support that, even though it hasn't been the 24 months yet since the original bill was enacted, what data or assumptions are based that increasing it by another year, what results would occur. So as soon as you can, because as you know, Senator, we are on a time crunch at this point for committee passage. So as soon as you could, please submit all of that data to the committee.
Absolutely, ma'am. That's our homework assignment. We're on it. Thank you.
Thank you, Chair.
Thank you so much. And with that, I will go ahead and close the hearing for Senate Bill 371. Next item on our agenda is public comment. Again, public comment is not to make any comment on any of the bills that were heard today, but for anything else that's under the purview of this committee. And with that, I will invite anyone here in Carson City that would like to come forward and make public comment. Not seeing any. Is there anyone there in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, please open the lines.
The public line is open and working. There are no callers to provide public comment at this time.
Thank you so much. Then with that, I will close public comment. We have concluded our business for today. So I will adjourn this meeting and see everyone back at 9 a.m. on Monday morning. Have a great weekend, everyone. You're welcome. We are adjourned.